December 7th, 2025. My name is DeVince McFarlane, and we are going to discuss the vagueness of the City of Wayne's open burn policy. We have to redo this video apparently because when you live stream it, I don't know if I'm thinking somebody's flagging some of the videos or something, but regardless, we'll get it right this time. So this is a addendum analysis. Policy reproduced with commentary. This is the City of Wayne open burn policy, or as it is titled, Policy for Controlled Fires in the City of Wayne. The following documents address the subject of open burning. These documents include specific language from the Wayne County Air Quality Division, City of Wayne codified ordinances. That's a lie. NFPA 1 and the AIA Fire Prevention Code. Here's my response. The document labels itself a policy for controlled fires, yet immediately pivots to open burning. Well, that's what it's titled. When you go on the city website, the PDF is named open burn policy, but then it's titled Policy for Controlled Fires in the City of Wayne. So which one is it? What's it called? Well, nobody knows. That's the mystery here. You'll notice this a lot. You'll notice the void for vagueness violations. The policy labels itself a policy for controlled fires, yet immediately pivots to open burning, terms the city never defines in any codified ordinance. This bait and switch creates uncertainty from the first sentence about what conduct is regulated. A resident reading this cannot tell whether the city is prohibiting open burning, prohibiting open burning, permitting controlled fires, or regulating both under different standards that are never coherently explained. Due process requires fair notice and workable standards. A moving target is constitutionally inadequate. See Grayned versus City of Rockford, GRAYNED versus City of Rockford, 408 U.S. 104, 1972. These documents include specific language from Wayne County Air Quality Division, City of Wayne Codified Ordinances, NFPA 1, and the AIA Fire Prevention Code. This sentence concedes the city has compiled a cut-and-paste memorandum from disparate sources rather than enacting a clear ordinance. Some cited sources do not prohibit open burning, Wayne County. Some are irrelevant. Christmas tree sales, junkyards, parks, and wrecking sites. Others are national standards never adopted in Wayne, the NFPA, and the AIA. And still others are phantom, sections that do not even exist in the city charter. Citizens cannot be subjected to criminal enforcement under a collage of materials that change with the enforcer's preference. Such unchanneled discretion is the core evil of the vagueness doctrine. Such unchanneled discretions is the core evil the vagueness doctrine forbids. See Papachristou versus Jacksonville, 405 U.S. 156, 1972. Papachristou versus Jacksonville. And then see Colender versus Lawson, Kolender versus Lawson, 461 U.S. 352, 1983. And then here we go. Let's get into the open burn policy, right? Let's continue. Wayne County Air Quality. Wayne County's 1998 ordinance does not expressly prohibit open burning. The policy admits the county does not ban open burning. This undercuts any implication that a larger governmental body has imposed a clear prohibition. Ordinance number 812.06. The burning of Christmas trees on a lot for the sale of the trees is prohibited. Well, that applies to commercial tree lots only, irrelevant to residential yards. So that ordinance is irrelevant for residential purposes. Ordinance number 832.17. The burning of junk and or any product resulting from dismantling of junk or automobiles is prohibited. Junkyards and auto dismantling, not backyard fire pits. So another irrelevant ordinance. Let's continue. Ordinance number 1062.13, no person shall light or make use of a fire in the park system except in such portions thereof as may be designated by the Department of Parks and Recreation. Applies to parks, not private curtilage, so we can continue. Ordinance number 1060.26, no person shall burn solid waste any place in the city other than in incinerators approved by the fire department. Again, that's solid waste regulation, not open burn ordinance, or isn't referring to open burning or fire pits in someone's backyard. So another irrelevant ordinance. Ordinance number 1060.27, no person shall burn any substance upon any street or alley of the city which has been surfaced with concrete or asphalt coating. Street and alleys only, not applicable to private yards. Let's continue. Ordinance 1460.07, the burning of material or debris on premises whereon wrecking operations are taking place or have taken place is prohibited. I want you to, again, or have taken place is prohibited. So I guess that would mean any place. It says premises. So any premises where wrecking operations have occurred in the past. So that would mean, I guess, every house then would be not allowed to have a fire pit or engage in open burning, because if you read it as it's written, again, we'll read it again. Ordinance number 1460.07, the burning of material or debris, right? So of material could mean anything. You know, wood's a material. Firewood would be a material then. Anything that has matter would be a material. The burning of material or debris, right? So material or debris, of course, these are not defined terms. On a premises whereon wrecking operations are taking place or have taken place is prohibited. So if you built your house, you cleared out the lot, which that would mean at some point every house, right? So if it has taken place already, that's prohibited. So I don't think that's the way they were trying to word it, but when you have people that are degenerates that try to sound smart, well, this is what you get. This is the result. This is Wayne, Michigan quality verbiage. No, this is the fire marshal, Jeremy Schneider. He's the one who actually wrote this. He actually wrote this. So let's continue. Wrecking demolition sites only, irrelevant here. Now, here's the goodies. Ordinance 1278. This ordinance deals with pollution and has technical measurements that we are not capable of determining for air quality. Isn't that something? Ordinance number 1278.07 addresses odors that may be offensive to neighbors. Well, what is may be offensive, and who's your neighbor, right? So a neighbor typically it would be a person you share a property line with, right? An adjacent property. But of course, they don't explain that. Well, here's where it gets really interesting. Sections 1278 and 1278.07 are phantom. These provisions do not even exist in the city's codified ordinances. They've been repealed a number of years ago. You can look it up for yourself. The policy nonetheless invokes them and astonishingly admits the city is not capable of determining the technical measurements it claims to enforce. This is a confession of legal interminacy and administrative incapacity. Residents are told to obey standards that both do not exist in the city charter and the city code and cannot be applied by officials. Vague, undefined, or non-existent standards violate due process because they fail to give fair notice and invite arbitrary enforcement. See GIACO versus Pennsylvania 382 U.S. 399, 1966. That's spelled GIACCIO. And also see City of Chicago versus Morales, Morales, 527 U.S. 41, 1999. All right, let's continue. NFPA 1, 2000 edition. Open fires shall be located not less than 50 feet from any structure. Open fire and cooking fires shall be constantly attended by a competent person until extinguished. A garden hose or other water supply shall be readily available for use. The fire department may prohibit all outdoor fires during a dry spell. These national standards may be sensible as guidance, but they are not law in Wayne unless duly adopted by ordinance. Borrowing standards by reference inside a policy PDF does not supply the clarity or democratic legitimacy the Constitution requires for criminal enforcement. Residents are entitled to rely on the published city code, not unadopted manuals. The mix and match approach also creates contradictions elsewhere in the policy, i.e. 50 feet versus 15-foot distances, compounding uncertainty. Open fires shall be best defined, not defined, best defined, which means that there's more than one definition here, which means that they're making up their own definition. Okay. Open fires shall be best defined as a fire on the ground, such as a campfire. The allowable minimum distance from the fire to a structure shall be 50 feet. This shall be allowed only by the approval of the fire marshal or his designee. So look at that, unlimited discretion. Isn't that interesting? Earlier portions suggest open burning is prohibited. Here, the policy authorizes open fires if two conditions are met: 50 feet from structures and fire marshal approval. There is no codified procedure to apply for, obtain, or approve, or appeal approval. There's no permit process, no timeline, and no criteria. This grants unbridled discretion to officials to approve some residents and deny others. A resident cannot conform conduct to a secret standardless approval regime. The contradiction, prohibited versus constitutionally allowed, combined with licensing by sheer discretion, is constitutionally infirm. See Co-Lender versus Lawson, 461 U.S. 352, 1983. Kolender. That's the unfettered discretion case. And then also see Coates versus Cincinnati, Coates versus Cincinnati, 402 U.S. 611, 1971. Subjective standards are void. Controlled fire shall be best defined as a fire within a manufactured enclosure that is designed to contain seasoned firewood or charcoal, such as a barbecue or a Coleman-type brand portable outdoor fireplace. The allowable minimum distance from a fireplace to a structure shall be 15 feet. Key terms are undefined. What qualifies as a manufactured enclosure? A metal bowl from a hardware store, a masonry ring, a welded drum? What counts as seasoned firewood? By moisture percentage? By time? By species? The policy provides no metrics. The 15-foot distance also conflicts with the earlier 50-foot distance quoted from NFPA, and the policy gives no rule for resolving conflicts. These layers of ambiguity leave ordinary people to guess at compliance and empower officers to declare violations ad hoc, exactly what Grayned versus and Co-Lender prohibit. Grayned and Kolender. Let's continue. A burning barrel, 55-gallon drum type, is not a controlled fire, all caps, and is prohibited, all caps, from use. Burning solid waste and yard waste is prohibited, all caps. This clause collapses several undefined categories: burning barrel, solid waste, and especially yard waste. The city provides no definition for yard waste. Does it mean branches, twigs, bark, mulch, or leaves? Worse, in practice, I was accused by both fire and police officials of burning miscellaneous vegetation, a phrase that appears nowhere in the city code or even this policy. The accusation itself demonstrates arbitrary enforcement. Ordinary logs and branches were relabeled miscellaneous vegetation to justify criminal charges. Criminal liability cannot rest on undefined, elastic, or invented terminology. See Papa Christou 405 U.S. at 170 and Colender 461 U.S. at 358. PAPACHRISTOU and KOLENDER. In summary, open fires, controlled small fires, and cooking fires are not specifically prohibited. There are certainly exceptions to this. And if the fire is on property not belonging to the person, i.e. parks, wooded areas, public lands, is too close to a structure, is unsafe because of any other reason, or is offensive to others, we have the right to seize the burning. Isn't that something right there? This paragraph encapsulates the policy's contradictions. It begins by stating fires are not specifically prohibited, and then immediately invents sweeping subjective exceptions. Phrases like unsafe because of any other reason and offensive to others lack objective content and allow officials to prohibit identical conduct for different people based on personal views. The Supreme Court has repeatedly invalidated such standards. See Coates versus Cincinnati, COATES, 402 U.S. 611, 1971. Annoying is void for vagueness. City of Chicago versus Morales, MORALES, 527 U.S. 41, 1999. Anti-loitering ordinance void for lack of minimal guidelines. When combined with the policy's earlier contradictions in undefined terms, this clause proves this scheme is standardless. Okay, here's the next part. It shall be the discretion of the officer to handle open burning complaints based upon all circumstances observed. This culminating grant of unbounded discretion confirms the policy is not a rule of law, but an invitation to selective, subjective enforcement. There are no definitions, no factors, no thresholds, and no procedural safeguards. Two residents engaging in identical conduct could be treated oppositely depending on the officer. Such unchanneled discretion is the precise vice the vagueness doctrine seeks to prevent because it chills lawful conduct and enables arbitrary punishment. See Colender, 461 U.S. at 358, Papa Christou, 405 U.S. at page 170. Ultra vires nature of the policy. Even if the policy for controlled fires was clear and internally consistent, it would still be unenforceable because it is ultra vires. The Wayne Fire Department lacks legislative authority to create binding criminal law. Only the City Council can enact ordinances through the codification process. At most, this policy is an internal guidance memo. Treating such a document as binding law exceeds the city's lawful powers and deprives citizens of the protections of notice, debate, and codification. Courts consistently strike down enforcement based on uncodified administrative policies because they deny due process, which is the 14th Amendment. Really, this whole policy is an affront to the 14th Amendment, but also the 4th Amendment, too, because, as the city of Wayne's previous actions have shown, they have zero issue violating the 4th Amendment to enforce this garbage. So, conclusion, the policy for controlled fires is an uncodified, internally contradictory, and standardless memorandum that cites phantom provisions, and unadopted manuals while relying on undefined terms and officer discretion. It fails to provide citizens with constitutionally required fair notice of what conduct is prohibited, violating due process under the 14th Amendment. Two residents engaging in identical activity could be treated entirely differently depending on an officer's subjective labeling, creating arbitrary and unequal enforcement. The vagueness of this policy has already manifested in practice. I was personally accused of burning miscellaneous vegetation, a term that exists nowhere in the city code or the policy itself. Such arbitrary and undefined accusations prove vagueness not merely in theory, but in enforcement. Because the officer's entry and commands were based solely on this void policy, the interference charge is fruit of the poisonous tree and constitutionally invalid. Furthermore, the policy's elastic and shifting terminology chills lawful conduct, leaving residents fearful of arbitrary punishment, for ordinary use of their own property. Under well-settled case law, Supreme Court precedent, including Grained, Papachristou, Colender, Coates, Morales, and Giacio, this policy is void for vagueness and cannot serve as the basis for any lawful command. Accordingly, the interference charge must be dismissed with prejudice. Respectfully submitted. DeVincent A. McFarland Sr., 2028 mayoral candidate for the city of Wayne, Michigan. And I hope this video has been informative.